In the tense hush of a packed courtroom, Judge Harlan Whitaker's voice cut through like a whip, his words laced with scorn as he sneered at the disheveled black man before him. "You think you can waltz in here and play lawyer? Boy, stick to flipping burgers. This ain't your circus." The gallery tittered, but within seconds, the man's calm rebuttal with a single, razor-sharp legal precedent left the judge's face draining of color, his gavel frozen midair. What followed exposed a brilliance that shattered every prejudice in the room, turning mockery into a reckoning no one saw coming. Judge Harlan Whitaker had presided over countless cases in the bustling county courthouse of Milford, a mid-sized city where the air always carried the faint tang of exhaust from a nearby interstate. At 62, with a reputation for iron-fisted rulings and a penchant for colorful asides that often veered into the personal, Whitaker commanded respect from a bar and fear from a bench. His chambers overflowed with plaques from conservative legal associations, and his robes hung like a badge of unyielding authority. On this particular Tuesday morning in late spring, the docket was routine, a string of petty thefts, DUIs, and one eviction dispute that promised to be as dry as the legal briefs submitted beforehand. The case that disrupted the monotony arrived just after the lunch recess. Marcus Hale, a 38-year-old man with close-cropped hair graying at the temples and a faded navy jacket that had seen better days, stood accused of violating a restraining order. The complainant, his former landlord Evelyn Hargrove, alleged that Hale had trespassed on her property 2 weeks prior, lurking near the rental unit he'd vacated under acrimonious circumstances. Hargrove, a sharp-eyed widow in her 70s with a voice like gravel, had called the police herself, her 911 transcript painting Hale as a menacing figure who refused to accept eviction. The police report corroborated her story. Hale had been found pacing the driveway at dusk, keys in hand, muttering about unpaid repairs and rights denied. He was arrested without resistance, booked, and assigned a public defender who, due to a scheduling conflict, had to bow out at the last minute. Hale chose to represent himself. Proesi, in legalese, a decision that raised eyebrows among the court staff. As the bailiff called the case, Hale stepped forward, his posture straight despite the shackles that linked his wrists. The gallery, a mix of locals and Hargrove's distant relatives, murmured as Whitaker settled into his high-back chair, adjusting his glasses with a deliberate slowness that signaled his impatience. "State your name for the record," Whitaker intoned, his voice booming through the speakers. "Marcus Hale, Your Honor," came the reply, steady and measured, with the faint lilt of southern upbringing smoothed by years in the North. Whitaker scanned the file, his lips pursing. "And you're proceeding without counsel today, Mr. Hale? That a bold move for a man with, what is it here, a high school diploma and a spotty employment history in manual labor?" The question hung in the air, laced with implication. Hale met the judge's gaze evenly. "Yes, sir. I believe I can handle my defense." A ripple of amusement passed through the courtroom. Whitaker leaned back, his chair creaking under his weight. He was known for these moments, jabs that tested a defendant's mettle, often leaving the vulnerable squirming. In Milford, where the courthouse saw its share of indigent defendants from the East Side neighborhoods, such comments were as common as the flickering fluorescent lights overhead. "Manual labor," Whitaker repeated, as if savoring the phrase. "Well, Mr. Hale, this isn't a construction site. This is a court of law. You think a few weekends fixing leaky faucets qualify you to navigate the intricacies of a restraining order violation? That's a felony charge. Son, up to 5 years if I see fit." Hale shifted slightly, the chains clinking softly. "I understand the charges, Your Honor. I'd like to enter my plea of not guilty." Whitaker's eyebrows arched. "Not guilty? The police report says you were caught red-handed on the property. Ms. Hargrove here swears you threatened her. You got anything besides your word to back that up?" The prosecutor, a young assistant district attorney, named Laura Klein, rose smoothly. Klein was efficient, her blonde bob impeccable, her arguments as polished as the mahogany podium. "Your Honor, the evidence is straightforward. The 911 call, the officer's testimony, and photos of Mr. Hale at the scene. We request remand pending trial." Whitaker nodded, turning back to Hale. "See that, Mr. Hale? Straightforward. But you're the one insisting on this pro-SE nonsense. Fine. Enter your plea." But let's make this quick. I've got real cases after lunch. Not guilty, Your Honor, Hale repeated, his tone unchanging. The judge sighed theatrically, flipping to the file with exaggerated boredom. All right, then, discovery's been provided. You want to make an opening statement? Or should we just jump to the prosecution's case and save everyone the trouble? Hale paused, as if weighing the room's undercurrent of skepticism. I'd like to make a statement, Your Honor. Whitaker waved a hand dismissively. Go on. Then, impress us. What followed was not the rambling denial the court anticipated. Hale straightened, his voice gaining a quiet authority that seemed to pull the room's attention like a magnet. Ladies and gentlemen of the court, Ms. Hargrove, I stand here not as a trespasser, but as a tenant wrongfully evicted, denied my due process under the law. The restraining order she obtained was based on fabrications, claims of non-payment that ignore the repairs I made to her property at my own expense. I was on that driveway not to harass, but to retrieve my security deposit and document the condition of the unit, as required by state statute. This case isn't about violation. It's about justice delayed for those who know their rights. The words landed with a precision that silenced the snickers. Whitaker blinked, his fingers drumming the bench. It was a solid opener, concise, invoking statute without overreach. But the judge recovered quickly, his skepticism hardening into something sharper. Poetic, Mr. Hale, but poetry doesn't pay the rent. Ms. Klein, call your first witness. Klein proceeded methodically, starting with Hargrove herself. The widow took the stand, her hands clasped tightly around a tissue. Under direct examination, she recounted the eviction. Hale had fallen behind on rent after losing his warehouse job, she said, and when she served notice, he became belligerent, pounding on her door late at night. The restraining order followed a heated exchange where, she claimed, he shouted threats. On the day of the alleged violation, she'd spotted him from her kitchen window, keys jangling, eyes wild. And did he leave when you called the police? Klein asked. No, ma'am, Hargrove replied, her voice quavering for effect. He just stood there, staring like he owned the place. Cross-examination fell to Hale. He approached the podium with deliberate steps, the chains of faint rattle in the quiet. Ms. Hargrove, he began, you say I fell behind on rent. Can you produce the lease agreement? Hargrove faltered, glancing at Klein. It's in my files at home. Objection, Klein interjected. Relevance. Overruled. Whitaker snapped, intrigued despite himself. Answer the question, Ms. Hargrove. I don't have it here, she admitted. Hale nodded, as if this were expected. That's fine, but you recall the clause on repairs? Section 4B of the standard Milford residential lease. Tenant may perform necessary repairs and deduct from rent, provided documentation is submitted within 30 days. Hargrove blinked. Yes, something like that. And did I submit documentation? Receipts for the plumbing fix in February, the roof patch in March. I don't remember, she said, her tone sharpening. Hale turned to the clerk. Your Honor, I'd like to enter Exhibit A, certified copies of those receipts, time-stamped and notarized, mailed to Ms. Hargrove's address on March 15th. The clerk handed up the documents. Whitaker took them, scanning the pages with a frown that deepened into confusion. The receipts were meticulous, itemized with photos attached, totals deducting neatly from the rent owed. These are in order, the judge muttered, almost to himself. Klein objected again, this time on foundation. Your Honor, this is a restraining order hearing, not an eviction appeal. The man's presence on the property was unauthorized, period. Whitaker considered, his eyes flicking to Hale. The defendant stood impassive, but there was a spark in his gaze, a quiet confidence that unsettled the judge. Sustained for now, but Mr. Hale, you may explore motive. Hale pressed on. Ms. Hargrove, those repairs kept your property habitable. Without them, the city inspector would have condemned the unit. You benefited. Yet you evicted me without refunding the deductions. Wasn't that retaliation? It was non-payment, she shot back. Objection, argumentative, Klein said. Sustained, Whitaker ruled, but his voice lacked its usual bite. He was watching Hale now, really watching, as if seeing him for the first time. The prosecution moved to the responding officer, Patrolman Derek Voss, a stocky veteran with a mustache that,